Good evening, everyone. It's my great pleasure to welcome Professor John Oberdiek to deliver one of the Hong Kong U Private Law and Theory lectures. Professor Oberdiek is a distinguished professor of law at Rutgers Law School and co-director of the Rutgers Institute for Law and Philosophy. He is a member of the American Law Institute and advisor to the Institute Reinstatement of Property. He has held visiting appointments at several institutions, including Columbia and Princeton. Professor Oberdiek has made important contributions to a wide range of topics, including tort law and contractualism, risk imposition and autonomy, and the personal nature of duty in tort law. He is widely regarded as one of the leading voices in tort law and is the 2023 recipient of the Fred Berger Memorial Prize in Philosophy of Law, awarded by the American Philosophical Association. I have learned a great deal from reading his work, and I'm sure that we'll all learn much from his talk this evening, entitled Negligence, Real Wrongs, and Relational Legal Redress. Without further ado, please join me in welcoming Professor John Oberdiek.
Thank you very much, Peter, for that introduction. Thank you all for coming. Thank you to Hong Kong U and to the Center for Private Law for inviting me. It's a real privilege to be here. It's a commonplace that litigation in private law takes a bipolar or bilateral form, with a plaintiff suing a defendant. The plaintiff has a right of action against the defendant that is grounded in having been allegedly wronged by the defendant. The bilateral relational form that legal redress takes on this picture is a reflection of the relational form of the wrongdoing, and thus of the primary duties that anyone owes to anyone else. It is because the defendant failed to heed the relational directed duty that they owed to the plaintiff and thus wronged the plaintiff, that the plaintiff now has a right to seek redress, specifically against the defendant for that wrong. Many private law theorists take this picture to speak for itself in a certain sense. It was overlooking the bilateral form of private law litigation, and tort litigation in particular, that was among the original sins of law and economics, according to Ernest Weinrib's and Jules Coleman's agenda-setting critiques of economic accounts of tort law. While economic theories offered accounts of the substance of tort law, they were silent about, and worse, could not make sense of, the bilateral structure of tort litigation, why it was that plaintiffs and defendants were necessarily joined together. Weinrib's and Coleman's explanation of this bilateral form was grounded in corrective justice. There is an essential connection between plaintiff and defendant, because the defendant has wronged the plaintiff, and as a matter of corrective justice, must right that wrong. The bilateral form of tort litigation, in other words, encodes a particular understanding of primary and secondary rights of duties, one that eludes law and economics. A great deal of tort theory since this first wave critique of economic approaches has been devoted to explicating distinct but allied conceptions of tort law, first inspired and articulated by Weinrib and Coleman, conceptions that revolve around rights, relational duties, and the wrongs that are constituted by the breach of such duties. These resolutely non-economic, rights-based accounts maintain that one cannot understand a tort law without recognizing that it is a system of primary rights and relational duties coupled with secondary rights of redress. As they are further refined, these accounts offer ever more subtle accounts of tort law in this vein. But it is increasingly clear that what makes these various rights-based theories accounts of tort law is their explanatory or interpretive purchase. They take legal doctrine mostly as they find it and offer something akin to a rational and to some extent moralized reconstruction of it. While these accounts do aspire to incorporate normative considerations into their interpretations of tort law, it is not just fit, but also justification that matters. They are not first and foremost normative accounts. An implication of this is that while leading accounts of tort law may present that body of law as a system of bilateral rights and duties, they cannot guarantee that the rights and duties they identify at the center of tort law map onto or reflect real rights and real duties, or that the wrongs that trigger litigation are real wrongs. If someone violates another's tort-based right, they may legally wrong that individual, but whether those rights and wrongs are but positivist fabrications or are instead authentic rights and wrongs, which are genuinely normative and actually reason-giving, is not settled by such theories. Tort law's self-conception may be as a law of rights, directed duties, and relational wrongs, but without more, and specifically, unless those rights, duties, and wrongs reflect moral rights, duties, and wrongs and are not legal ones alone, that self-conception may just be what Liam Murphy has called an illusion. My first aim here is to come to terms with this challenge, issued most forthrightly by Murphy. It is a challenge that amounts to a broadside against a majority of contemporary rights-based private law theory. I argue that, at least to the extent Murphy's challenge is directed at tort law, and specifically at negligence, it can be turned back. Another aim I have is to identify and address a gap in accounts of tort law that locate rights, duties, and wrongs at their center, a gap that Murphy's challenge illuminates, albeit indirectly. Tort law may in fact be structured by the concepts of rights, duties, and wrongs, and, as I argue in what follows, the best moral justification of tort law may also appeal to such concepts. Yet it does not necessarily follow that relational morality can only be realized in an institution that is itself structured relationally. In this respect, it seems to me that Murphy's instrumentalist challenge can be repurposed, prompting me to explore whether relational legal redress is special and in some sense morally necessary. I contend that it is. In recent work, Murphy has challenged the rights-based orthodoxy in private law theory. He concedes on the one hand that of course domains of private law like contract, property, and torts are systems of primary rights and duties coupled with secondary ones, entailing that violations of primary rights constitute wrongs. But he nevertheless denies that this reflects any deeper moral reality, at least in the main. Instead, Murphy argues that it is far more plausible to suppose that private law's domains are purely formal legal arrangements, which are justified by open-ended instrumental considerations like aggregate well-being, freedom, justice, and autonomy, among other values, either individually or in combination. On Murphy's view, in short, quote, morally significant social benefits flow from the social practices of private law, and it is those generalized social benefits that justify the law, including its relational structure. His summary of his view of contract law is representative and merits quoting at length. So here I quote Murphy. So we see that the law of contract inevitably has a deontological structure where there are clear rights and duties, clear violators, and clear victims. But the justification for this deontological structure is not that there are individual moral rights and duties that should be enforced, even if judges should perhaps read the rules straight and apply them formalistically. Legal theorists trying to find the point and rationale of contract law should not take the content of the rules at face value. The surface of the doctrine has it that promisees have contractual rights, which correlate with duties on the part of promisors. This deontological structure of the legal doctrine naturally suggests that it is aiming to reflect real natural rights and obligations that people have. But on the correct moral evaluation of contract law, all of those legal rights and obligations have no independent intelligibility. They do not reflect moral rights. They are features of a complex system of overlapping normative orders that together must be justified instrumentally and holistically. That's the end of the quote. It is true that contract law appears to reflect an underlying promissory morality then, but there is no independent promissory morality. There's only a convention of promising that's beneficial or otherwise valuable and thus worth maintaining. And on Murphy's view, what goes for contract law goes for property and also most of tort law, including the signal tort of negligence. There are no underlying moral rights here either, only instrumental justifications in terms foreign to the law's own self-conception. Now, what Murphy's foregoing summary statement leaves out, of course, is an argument for the claim that, quote, all of those legal rights and obligations have no independent intelligibility, unquote. Indeed, on his view, there is no one argument. Instead of offering a single encompassing argument, Murphy advances a collection of distinct arguments directed separately at contract, property, and individual torts. In all such instances, Murphy contends that there is no thoroughgoing underlying moral reality, almost no what he calls natural moral rights upon which the positive legal rights are based. We are misled into thinking otherwise because of the surface features of these areas of law with the obvious role that they accord to rights, duties, and wrongs. This is the illusion. Murphy seeks to debunk private law's self-conception, to reveal that while it trades in rights, duties, and wrongs, it is not morally justified in those terms. My first and primary aim is to take on that wing of his project that seeks to debunk tort law, focusing on the tort of negligence. I focus on defending the independent moral intelligibility of the tort of negligence specifically, because Murphy believes that certain other torts are in fact anchored by real moral rights. Murphy concedes, for example, that the tort of battery has independent moral intelligibility. As he puts it, quote, I have natural rights against you that you not harm me or impede my free movement, unquote. But he denies that negligence, which stands at the center of the practice of and theorizing about tort law, has any similar moral intelligibility. I disagree with Murphy. It is my view that the tort of negligence has every bit of independent moral intelligibility that he acknowledges the tort of battery has. Now, before trying to defend that claim, a quick primer on the common law tort of negligence. The tort of negligence is composed of elements: injury, duty, breach, actual, and proximate cause. If the plaintiff can establish all of those elements by a preponderance of the evidence, the plaintiff has established the prima facie case, and if the defendant has no affirmative defenses, the plaintiff wins, and the next question is damages or liability. That is, what the defendant now owes the plaintiff remedially. The answer to this question is straightforward in principle, even if not always in practice. The defendant owes the plaintiff for all the pecuniary or economic losses the defendant inflicted on the plaintiff, as well as non-pecuniary losses like emotional distress. This will depend on what exactly happened to the plaintiff on account of the tort. For example, whether they were hospitalized, the extent of the medical care they received, whether and how long they missed work, the significance of any emotional distress suffered, and how much the injury interfered with the rest of the plaintiff's life and their relationships. This is straightforward positive law, and it all may be justified on Murphy's view. But if it is because this complex arrangement advances goals that are independently morally valuable, not because this social practice gives expression to underlying primary and secondary moral rights, which have a relational structure. Regarding negligence, Murphy contends, we don't have to reject the reality of moral luck, to reject as morally perverse the massive difference factors outside people's control can make to the extent to which they have, in the eyes of tort law, wronged someone. A natural duty to take care is entirely plausible, perhaps even implied by the natural duty not to injure intentionally. What is implausible is an outcome-inclusive moral duty not to injure negligently. So for negligence, I line up with the instrumentalist camp that sees the point of this normative order as attempting to promote the twin goals of compensation and deterrence. Murphy is here making reference to long-standing theories of tort law in competition with rights-based ones, which hold that tort law is in effect a complex regulatory system whose point is to compensate those who suffer injury and or to deter those who would inflict them without exercising due care. They are unabashedly instrumentalist. Murphy sides with them and against rights-based accounts because the latter supposedly incorporate an outcome-inclusive duty, a duty not to cause injury through careless conduct. The problem, as Murphy sees it, is that this cannot but make the duty beholden to, as he puts it, factors outside people's control, factors, moreover, which will largely dictate how much a careless agent owes to whomever they have injured. These are departures from anything interpersonal, relational, rights-based morality could underwrite, on his view. So if negligence law is justified, it is not because it reflects moral rights and duties, according to Murphy. It must be because having it advances some other goals, though he is open to the possibility that some other artificial normative order, something altogether different from tort law, could advance those goals just as well or better. Murphy spends little time substantiating the claim that the outcome-inclusive duty that he identifies at the center of the tort of negligence is in fact the duty at its center. I suspect he glides over that initial assessment because so many rights-based tort theorists take precisely that position. John Gardner, Arthur Ripstein, and John Goldberg and Benjamin Zapersky have all defended conceptualizing the duty in negligence in just that way. But I believe that they are all mistaken. The most compelling account of the duty at the heart of negligence holds that one must take care with respect to those whom one can reasonably foresee injuring, but does not require that one not in fact injure anyone. In this way, I maintain, wronging another consists in breaching a relational duty of care, whether or not one injures those to whom one owes the duty. This alternative conceptualization of the duty reveals that the tort of negligence revolves around what Murphy would regard as a real duty. He is, after all, forthright that, quote, a natural duty to take care is entirely plausible, end quote. And it is a short step from that position to mine, which is different only in requiring that the duty be directed. Why, then, does Murphy think that that is not the duty that negligence law is based upon? It would seem that he is inferring the content of negligence law's primary duty from the liability that follows from tortiously injuring another. That is a mistake. It is an illicit inference because it fails to respect the distinction between duty and liability. It is far clearer and more straightforward to hold that everyone owes only a duty of care to those whom they can reasonably foresee injuring, such that the wrong of negligence consists in breaching a relational duty of care, quite apart from whether one also inflicts an injury. That negligence law holds one liable for the injuries that one tortiously causes does not imply that the duty at the heart of negligence is the outcome-inclusive duty not to injure. One can simply be liable for the negative material consequences of having breached a relational duty of care. And that is a good thing, not just as a matter of conceptual hygiene, but because I believe Murphy is entirely right to reject the plausibility of an outcome-inclusive duty as a real, normative, reason-giving duty. That is because it fails to satisfy one of the most basic desiderata of a real duty, which is to be able to guide action. As Stephen Perry bluntly puts the point, quote, "There can be no ex ante duty except in the most formal sense, not to cause harm to others," end quote. The problem with an injunction not to cause injury, as opposed to one to take care not to cause injury, is that it can only be heeded by luck and validated after the fact. Judith Jarvis Thompson captures what is objectionable about this when she maintains, quote, "We do not think that the permissibility of acting under uncertainty is to be settled only later when uncertainty has yielded to certainty," end quote. One must be able to assess the permissibility of any course of conduct ex ante before the consequences of what one does have unfolded. Whether one has complied with an outcome-inclusive duty, in contrast, is something that, by definition, can only be settled later, once the possible outcome either has or has not occurred. By that point, of course, it is too late to inform the decision of whether or how to act. Unlike an outcome-inclusive duty of non-injury, a duty of care is something with which we can comply ex ante. It is action guiding, for we can assess the permissibility of action in advance in complying with the duty of care. This is crucial, for in Frank Jackson's words, quote, "The passage to action is the very business of ethics," unquote. This suggests that Murphy's concerns can be allayed. The law of negligence is best conceived as not incorporating an outcome-inclusive duty not to injure, but simply a relational duty of care, and Murphy recognizes the independent moral intelligibility of that latter duty. Yet I doubt that reconceptualizing the duty at the center of the tort of negligence, decoupling duty from liability as I recommend, addresses Murphy's most basic concern. His elision of the duty-liability distinction obscures what I take to be the crux of his complaint against the tort of negligence. It is not so much, I think, that the duty is supposedly outcome-inclusive, nor that the extent to which anyone has wronged someone answers to moral luck. It is at bottom a concern with liability. Murphy's fundamental objection seems to be that negligence law requires careless actors to compensate those whom they injure for the full extent of their injuries, even though that extent will not itself be subject to the control of the careless actor who is so liable. In this way, Murphy is co-signing Jeremy Waldron's well-known argument against tort law, which revolves around the potentially ruinous, unfair liability consequences for tortfeasors. As it happens, those rights-based tort theorists who Murphy follows in identifying the duty in negligence as outcome inclusive are largely driven to that position, again mistakenly in my view, as a response to Waldron, who chides the law of negligence for treating two equally careless actors differently when only one of them causes an injury. Why shouldn't careless driver Fortune owe compensation to anyone when they were no less careless than other driver Fate, who alone happened to crash into someone and who is now legally obligated to pay an enormous amount of money for the injury they have inflicted? Gardner, Ripstein, and Goldberg and Sapersky all offer the same broad response. Two actors may be equally careless, but the relevant duty is not one of quote-unquote non-injuriousness, but of, as they call it, non-injury. So in fact, only one careless actor wrongs anyone in Waldron's scenario, for only one actor causes injury through their carelessness. This tack allows for the discrimination between Waldron's fate and fortune, making sense of negligence law's manifest commitment to holding liable those and only those who injure others. It is true. It does so, however, at the cost of rendering the duty morally implausible, as Murphy rightly observes, yet all needlessly so. On my alternative conceptualization, where one is duty-bound simply to exercise due care with respect to foreseeable others, one can also discriminate between Waldron's drivers. The basis for doing so, however, differs. The reason one only provides a right of redress to those who have been wrongfully injured, rather than to anyone who has been wronged, is that only when a wrong also injures is there anything to redress, at least with the monetary means that tort law employs. In a situation where one wrongs another but does not inflict a legally cognizable injury, Charlie Webb points out that, quote, there is no harm to undo or loss to make good. There are no consequences which the law might demand I correct or offset, end quote. Wronging another without injury then may well call for a response, but it is not one that tort law underwrites. And tort law need not reflect the whole of morality to reflect morality. So, without an injury, there's nothing material to redress. A compensatory damages award is therefore pointless. This response may appear to play into Murphy's hands. For again, Murphy, quote, rejects as morally perverse the massive difference factors outside people's control can make to the extent to which, end quote, and here we have to amend the charge to acknowledge the duty liability distinction, that they must compensate those whom they carelessly injure. In this light, his charge is best understood as a direct challenge to the liability that follows from carelessly injuring someone. It turns out to be the secondary duty or right of redress that is, quote unquote, morally perverse. Why should fate be bankrupted while fortune evades any liability at all? How could our best conception of real rights and duties permit that? If this is in fact the ultimate charge, it overlooks the fact that there is no damages rule that is unique to the tort of negligence. There is only tort law's all-encompassing damages award. Regardless of the tort, in other words, a successful plaintiff has a right of redress that entitles them to a full compensatory damages award, which can balloon depending on the extent of their injuries and more general setbacks in life, an extent that can be based on factors outside the defendant's control precisely because they will be responsive to highly individualized facts about the plaintiff. The reason that this matters and why Murphy's apparent oversight causes mischief for him goes back to his endorsement of the independent moral intelligibility of the tort of battery. Recall his comfort in holding that, quote, I have natural rights against you, that you not harm me or impede my movement. The issue is that if that morally plausible primary right is violated, it triggers a secondary right of redress in the plaintiff against the defendant, who may end up owing the plaintiff a massive compensatory damages award depending on the highly individualized impact the battery has on the plaintiff. The secondary right triggered by battery is precisely the same secondary right triggered by negligently harming another. What Murphy seems to object to about negligence is therefore also a feature of battery. Put another way, the parable of fate and fortune need not be confined to the tort of negligence. If fortune slaps someone, and without more, the victim will of course have a winning battery case against them, but the damages award will be slight. If fate does the same thing, but his victim is a hemophiliac and the slap triggers internal bleeding that leads to brain damage, fate will be liable to the victim for a huge sum of money, even though fate's slap was no harder than fortune's, nor calculated to hurt or to harm any more. The puzzle distilled is this: if the tort of negligence is morally implausible on account of its liability consequences, then the tort of battery should be morally implausible as well on Murphy's view, and yet Murphy finds the tort of battery morally plausible. Now, one person's modus ponens is another's modus tollens. Rather than causing him to rethink the moral credentials of the tort of negligence, perhaps the foregoing would instead cause Murphy to reconsider his endorsement of the moral reality of the tort of battery. For it is now clear that endorsing battery's moral reality appears to entail endorsing the secondary right that follows in its wake, which in turn stimulates the same concerns that Murphy thinks warrant rejecting any underlying moral reality for the tort of negligence. It is ultimately the liability consequences of tortious conduct that appears to exercise Murphy. This in turn suggests a still different position someone sympathetic to Murphy's concerns could adopt. One could admit that the primary rights and duties upon which the torts of battery and even negligence are based are authentic rights and duties, but maintain that all secondary rights and duties can only be instrumentally justified. If it is tort law's regime of liability that most concerns Murphy, then sharply distinguishing the bases of tort law's primary rights and duties from those of its secondary rights and duties when it would enable one at once to acknowledge the authentic relational normativity of the former while justifying the latter only instrumentally. Another way to put this point would be to hold that all of the individual torts, including negligence, reflect real wrongs, but that the damages rule that tort law adopts for its myriad torts is entirely and merely instrumentally justified. This is no doubt a possible move. Indeed, there is no doubt that various aspects of any complex legal order are wholly conventional and justified on instrumental grounds. It is crucial, however, not to overstate the scope of this point. Assigning the remedial wing of tort law as a whole an exclusively instrumental justification would, I believe, be a case of overstatement. Rejecting the moral reality of secondary rights and duties, their relational structure, and their compensatory aims is implausible. To be clear, were one to take a debunking instrumental approach on this score, one would not be committed to denying the moral justifiability of our legal practice of holding people accountable for the extent of the injuries they tortiously cause. One would instead be denying only that there are any underlying moral rights or duties to which that practice answers. Still, our non-legal practices of apologizing and making amends for wrongfully harming others all point to there being moral rights and duties here, which tort law in turn institutionalizes in its secondary rights and duties. Of course, were Murphy to follow this path, he might consider that appearance an illusion as well. Little different from what he contends is the illusion of a promissory morality that can stand apart from conventional practices and actual explanations. But it seems to me very difficult to shake what seems to be the morally foundational thought that if one wrongs another, one owes them an apology, and that if one harms another in wronging them, one must make it up to them as best as one can. More generally, it seems very difficult to shake the thought that wronging another has implications for what the wronging party owes to the victim and what the victim has a right to demand of their victimizer. Just as one has independently morally intelligible primary rights and duties, one has independently morally intelligible secondary rights and duties. This does not mean that conventions and other social practices are irrelevant. Far from it. Our specific forms of apologizing are surely practice dependent. At the thin edge of the wedge, Saying sorry itself is only possible because of language. It's self-conventional. And this is to say nothing of thicker apologetic practices like sending flowers. Our specific forms of legal redress, in particular the ubiquity of compensatory damages awards, are practice dependent as well. Compensatory damages awards are additionally conventional, for money itself is of course purely conventional. Admitting the conventionality and practice dependency of these norms, though, will not lead to Murphy's conclusion. For the fact that the particulars of the operationalization of our secondary rights and duties are conventional does not show that those rights and duties themselves are purely conventional or projections of an artificial normative order justified only by instrumental considerations. At the foundations of our conventional, reparative, and remedial practices lies a moral principle. Conventions give it concrete expression. While any particular conventional or instrumentally justified operationalization of that moral principle is discretionary, giving the principle some concrete form is not. In this respect, one's secondary legal rights and duties have all the independent moral intelligibility that our primary legal rights and duties do. No one denies that conventions are relevant and indeed important. The debate concerns their location and role. It is, of course, true that compensatory damages awards can be massive and are certainly not necessarily reflective of anything like a defendant's moral culpability. Anglo-American tort law is chock full of cases where a modestly culpable defendant is liable for a massive judgment. Waldron, for one, makes much of this fact. But it would be positively strange if a plaintiff's right of redress against a defendant tracked the defendant's culpability, insofar as the redress is meant to redress what happened to the plaintiff and is not an indictment of the defendant. Tort law and criminal law are quite different in this way, and it is surely relevant that only tort law empowers someone who was wrongfully harmed to do anything about it. It is the victim's harm that takes center stage in tort litigation. The instrumentalist may try to appropriate this insight by claiming that the compensation of harm is a goal worth pursuing, but they will not be able to recognize that the harm is anything more than a free-floating disvalue. Unless they can connect that harm to the tortfeasor's agency and recognize it as the product of a wrong, however, they will fail to capture the phenomenon. Capturing the phenomenon necessitates abandoning instrumentalism, because doing so is just to recognize that the harm is the product of a wronging, a failure to heed a relational duty, and the violation of a right. Relational legal redress is the phenomenon, and it can only be explicated persuasively in relational moral terms. So, compensatory damage awards can be massive. There can be a massive difference between what two equally careless defendants owe, but that will be due to what the respective plaintiffs suffered. Even those liability regimes that cabin damages awards the most, like the schedules of benefits familiar from American workers' compensation schemes, account for differences between what happened to those injured. A lost leg, for example, is compensated more than a lost finger. This is not to say that there is nothing to Murphy's moral perversity charge. Not all massive differences in liability are created equal, even if tort law traditionally regards them as such. If you carelessly crash into Mick Jagger's Rolls Royce, to borrow James Penner's evocative example, tort law stands ready to demand that you pay Jagger to repair his very expensive car. This can make tort law seem morally perverse in just the ways that Murphy and Waldron identify. But we should be careful not to saddle tort law with the sins of distributive injustice, for starters, nor should we assume that the precise way that tort law calculates damages awards is the only way that it could, while remaining faithful to its animating ideals. not all massive differences in liability are created equal, because not all potential operationalizations of our secondary moral rights and duties are created equal. The crucial point is that it would be morally perverse not to permit at least certain massive differences in damages awards, because to bar them would wrong the victim all over again. Our secondary moral rights, when triggered, exert as much normative force on others as our primary rights do. If another's careless act forces one to give up one's dream career, or causes one to lose all mobility, or plunges one into a deep depression, the fact that someone else exposed to the same risk created by the one who harmed you escaped any suffering or loss does not change what happened to you. Your life is still in shambles. Tort law steps in here to rectify that to the extent possible with the only tool it has at hand, namely money. And it seems to me that the warrant for that is an underlying secondary moral right, granting that the specific details of its operationalization may be purely conventional. To say that any such massive difference in liability is morally perverse, as Murphy does, is overstatement. Great differences in liability as such are not what matter morally, undermining tort law's remedial wing. For such differences in liability are not only sometimes morally permissible, they may be required, and indeed required as a matter of moral principle, as a matter of moral right. If what I have argued in the foregoing is correct, it undercuts the inevitability of purely instrumental justifications of the tort of negligence. The tort's legally enshrined primary duty of care is supported by a primary moral duty of care, while its secondary right, entitling a plaintiff who has been wrongfully harmed to damages, is supported by a secondary moral right of redress. Those who seek to justify tort law, and specifically negligence law, can therefore do so directly, taking the surface features of the tort of negligence at face value, and need not be forced into appealing to instrumental considerations to do so. Whether or not he is right about the exclusively instrumental foundations of property and contract law, Murphy's skepticism about negligence law's independent moral intelligibility is, I have argued, misplaced. For those tort theorists who hope only to vindicate the surface features of the tort of negligence, this is enough. The common law of negligence does indeed have a principal justification, and it is one grounded in relational moral norms. If, however, one is also interested in what legal regimes could be justified by relational moral norms, if one is interested in what we might call the justificatory scope of relational moral norms, then matters are more complicated. For it does not follow from the fact that the relational norms of negligence law can be justified by relational moral norms that relational moral norms can only support relational legal norms. It is in principle possible for relational moral norms to find legal expression in a way that effaces that relationality. If so, then relational moral norms might be able to justify a legal regime that does the work of tort law, but that bears little resemblance to tort law. This is the possibility that I conclude by exploring. Think again of workers' compensation schemes. In the United States, if one is accidentally injured in the course of one's employment, then instead of having a private right of action against one's employer sounding in negligence law, one simply notifies one's employer of the injury. The employer in turn notifies a state agency, and one is then paid a predetermined amount either by the state, an insurance company, or by the employer, all regardless of whether the employer was at fault for one's injury. Consider also New Zealand, which famously replaced tort law outright in cases of accidental injury with a generalized insurance scheme, so that if one is injured in nearly any kind of accident, again, regardless of anyone's fault, one simply files a claim with the state for compensation. Perhaps everyone's taxes will rise as a consequence, but the party responsible for the injury is not uniquely accountable. There seems to be little trace in these arrangements of the picture of one person wronging another and the victim having a right of redress against the rights violator. If we think of relational moral norms as constituting that domain of morality concerned with what we owe to each other, it may seem that no such arrangements could be justified in those terms. But even if that verdict is ultimately correct, we should reach it cautiously. It is possible that there are systems that are in fact justified by relational moral norms, even though they dispense with a relational legal structure. Perhaps they are, in fact, despite appearances, arrangements that we collectively owe to one another. Just as values like aggregate well-being, freedom, justice, and autonomy can support legal orders that trade in rights, duties, and wrongs, this is just Murphy's point, so too relational moral norms can in theory support legal orders that do not. Whether it is a workers' compensation scheme or New Zealand-style social insurance against accidentally caused injuries, it is at least an open question whether, to appropriate contractualism's way of articulating relational morality, anyone could reasonably reject a principle for the general regulation of conduct that licensed such legal arrangements. How could this be, and what could justify any such cleavage? In the first instance, to command legitimacy, law needs to be responsive to certain kinds of values, like transparency, efficiency, and administrability, among others, that morality does not. Even if one has misgivings about the independent moral intelligibility of the strict liability that workers' compensation schemes or New Zealand's generalized insurance program relies on, perhaps strict liability can nevertheless be justified more elliptically and find an acceptable home in the law, following Thomas Nagel's line in maintaining that strict liability, quote, may have its legal uses, but seems irrational as a moral position, unquote. The thought would be roughly that the fault-based accountability that is emblematic of relational moral norms might best be served by effacing that. Now, this is an entirely familiar general maneuver. It is definitive of indirect forms of consequentialism. Sometimes maximizing the good is best achieved by not trying to do that. Well, we can say the same here about relational morality. So this all matters when we shift our attention from trying to justify tort law, or more specifically the law of negligence, which is the preoccupation of tort theorists, to considering whether our extant law should be reformed or how the law can best meet new challenges. Goldberg and Zapersky, for example, quote, are open to the possibility that it would be better, all things considered, to address some or all of the behavior that has been addressed through the wrongs and redress framework of tort law by law that operates on some other principle. One could imagine a muscular and encompassing regulatory regime, one that dispenses with private rights of action and indeed makes no reference at all to relational moral rights or duties, but is nevertheless justified by relational moral norms, entirely displacing tort law. There are, of course, already limited instances of this in every industrialized nation. Can we say only that tort law's framework of rights, duties, and wrongs is justified, but no more so than any number of other institutional realizations of the relational moral norms that justify tort law? Or is relational legal redress special? Now, aside from pragmatic reasons in favor of the tort law that we have, it would of course be costly to start from scratch. I want to focus on a principled reason why we might think that tort law is special. It's one that draws attention to what would be lost if tort law were to be replaced by a non-relational, non-rights and wrongs-based legal institution. It seems to me that where there are genuine, real rights paired with relational duties, failing to create legal institutions that reflect that relational morality risks the alienation of those whose rights and duties they are, for it mutes the standing that anyone has to be treated as their rights demand. Institutional arrangements designed to respond to the strictures of relational morality, but that depart from a relational legal structure, risk obscuring the fact that persons are the sources of claims who are owed treatment as a matter of individual right and are therefore the object of directed duties, who are capable of being wronged and not merely being treated wrongfully, and who can call their wrongdoers to account and demand that they redress the rights violations that they have inflicted. Tort law does all of these things. Its alternatives do not necessarily do that. It would undermine the moral status, on my view, of persons, not as beings of intrinsic moral importance, but as beings who are owed treatment of a certain kind by others if we were to depart from tort law. One feature of the common law of torts that serves as a bulwark against alienation so conceived is that highlighted by civil recourse theory. Those victimized by a wrong have the power to call their victimizers to account. Putting our rights in our hands, as it were, helps ensure both that we appreciate our moral status and that that status is socially recognized. Armed with a private right of action, more specifically, we are reminded that we are beings with moral rights who can in turn stand on them. That this feature of the common law of torts suffices to fend off alienation, though, does not show that it is necessary. It may be that it is not. If an adjudicatory body were vested with the exclusive authority to bring claims on behalf of those apparently wronged, then while the power of a claim right would not be in the hands of those whose rights it is, this arrangement might still show enough fidelity to the underlying moral logic that it would prevent alienation. That's an arrangement that isn't ours, but it is nevertheless recognizable as tort law. There are arrangements that wouldn't do the job. Certain workers' compensation schemes, at least, as well as New Zealand's public insurance program, run into difficulty on this score because they don't articulate any conduct as a wronging. They don't articulate it as a wrong at all, only as a response to injury, whether or not it was the product of a wrong. Institutional arrangements that fail to identify or respond to wrongs, as well as those that wholly sever the connections between a claimant and whomever has wronged them, risk alienation the most. First, even if anyone who is wronged is compensated through such arrangements, no recognition is given to the wrong, and indeed no one is being compensated in virtue of having been wronged. Consider the following analogy. If someone breaks the heart of their spouse by cheating on them, but only apologizes for causing their spouse deep sadness, that apology will not appropriately register the fact that the spouse was owed fidelity and was wronged by the infidelity. Legal compensation predicated on bare injury misfires in just the same way that the cheater's apology does. The injury and the sorrow, respectively, have the particular character that they do because they're each the product of a wrong. They're not simply impersonal states of affairs that we would all rather avoid. Let me conclude with the following. In expounding on Francis Cam's conception of moral status, Thomas Nagel observes that to be tortured would be wrong, but to be tortured and also to be someone it was not wrong to torture would be even worse. The concern that Nagel pinpoints here is alienation from one's moral status. It is definitional that it is bad to be harmed, and likewise, it is definitionally true that it is good to be compensated for any harm suffered. But if one is wrongfully harmed, and the fact that the harm was wrongfully inflicted is not acknowledged by whatever system is meant to protect and compensate one, one's moral status is undermined. To paraphrase Nagel, to be harmed is bad, but to be harmed and not have the harm acknowledged as wrong is worse. So, in light of this, relational moral norms, it seems to me, seem strongly to favor a relational legal regime, very much like the common law of torts. There is therefore a great deal of reason to be skeptical of its replacement by something that does not appeal to its underlying animating ideals in that way. Thank you very much.
So thank you very much, Professor Oberdiek, for this really interesting and thought-provoking lecture. So in the interest of time, we may only have time for a couple of quick questions. So can I invite questions from the floor? Yes, Michael?
Thank you. Interesting talk. As a New Zealander, I was naturally going to ask about the compensation scheme and see what you wanted to say.
I'm sorry to deliver bad news.
That's okay. No, but the point I ask is your idea of alienation, that if we sever the compensatory scheme from the moral obligation, then we take the risk of undermining the moral integrity in the first place, almost create moral hazard. it would suggest we can go around in New Zealand committing negligent acts without any concern, as long as they involve injury. Of course, it remains liable for property damage. I damaged Mick Jagger's car, I'm still liable for it. But that's not what happens.
Right.
The reality is New Zealanders, I think, are just as careful as any other civilized community in that sense. The sense of a duty of care is just as present. So does it matter? Is there then alienation? You at the end were saying maybe you can still justify these other legal regimes, but the general sense is that New Zealand is not really a very valuable or worthwhile system, that is second best to a tort regime.
Yeah. So two things. One, in the section of the paper that I didn't actually share, I'm not making an all things considered judgment, because it may well be that there are very pragmatic reasons to think that although alienation is deeply important, it's not the only value that matters, and it might have to give way in light of, say, efficiency concerns. New Zealand's method is much cheaper, for example, than what we have. But I think you'd be losing something that's important by because I think you'd be inviting alienation. So this brings me to your main point. I don't think it's a moral hazard concern that I'm identifying. I'm not suggesting that anyone who's in New Zealand is going to operate any differently than they otherwise would. It's rather that if you simply submit to what is in effect a regulatory regime, where you're getting checks cut to you in the mail when something bad happens to you, that check isn't reflective of your standing. Now, that doesn't mean everything falls apart. Everybody's still going to behave carefully, because I take it your premiums will go up in other ways if you don't, or things like that. It operates just like insurance. So my concern is not that people are going to act any differently. It's rather, in a way, what it reflects about the people subject to it. That's the thing that I think is lost in that regime. Yeah.
Thanks, John. Fascinating talk. I had a couple of questions. I'll try and make them very brief. So the first one is, you gave us a really interesting story as to why it's appropriate for the law to just recognize or enforce a subset of your moral duties. But why is your story preferable to the Kantian story for why that is the case, which is just, yes, we may have moral duties to take reasonable care, but the only moral duties that are legitimately enforceable, that are that subset that we can coerce, that subset where you injure someone, right? Because that's the only time on the Kantian account that you make a material difference in terms of someone's reciprocal freedom, right? So why is that story not a simpler, more elegant solution for why we only enforce a subset of our moral duties? And then the second question was, and I may have misunderstood. I think there was a part here where I couldn't follow exactly what you were saying, and that may be my fault, which was you suggested that we might have primary duties that are non-instrumentally justified, but then secondary duties that are instrumentally justified. And I thought that seems quite odd to me, and I may have misunderstood what you were saying, but I think on most people's conception of what it is to have a duty, it follows from the fact that if you violate the duty, there's some sort of secondary reparative duty that follows from that. And it may be a separate question whether we always enforce that duty or not, but that there is a necessary connection, at least apart from the economist's view of the world, but anyone who recognizes that there's some sort of moral concern going on would recognize that part of the story as to why we have the secondary duty is the primary duty. And so there must be some sort of connection there. And I was wondering if what the view that you were putting forward, although I think you ultimately reject it, would sever that connection, or how that would work. Thanks very much.
Sure. So let me start with your second question. My position is not that the secondary duties have only an instrumental justification. I think that they have the same principled foundation that our primary duties do. I was supposing that one, in a sort of Murphian vein, might try to preserve parts of that view by saying, what's instrumentally justified is just the remedial wing. But I think that's what falls prey to, like, what we think about the importance of apologies, and these are richly moral practices that we engage in, which I think just find expression in legal institutions. And indeed, like you, I think that those are connected to the primary duties. I believe in continuity there. On your comment about the Kantians, I don't think so. Very roughly, the Kantians are going to say that unless something actually interferes with someone's life or property, right, their person and their things, it's not enforceable because nothing has actually happened to them in a particular way. Their rights haven't been infringed. So two things. One, they still appeal to the outcome inclusive duty. It's, for example, Arthur Ripstein's view that you can't disaggregate the elements of the tort to sort of find the moral nerve of the tort because it all hangs together or it doesn't work at all. Okay, so he's one of the people who thinks that you have to sign on to that outcome inclusive duty. That's something that I find morally implausible, but I think you can actually preserve a lot of what the Kantian goes for so long as you recognize that there's a right against risk impositions. So you can still keep a rights-based framework and say that what we can't tolerate are people imposing certain risks on you that violate the right that you have against being risked under certain circumstances. So it can still be Kantian. I don't mean to be making an argument that they couldn't accommodate this, but I do think that the simpler view is to say that the wrong just consists in the breach of the duty without saying it also has to have a material effect on your well-being or something like that the injury imagines.
So Liam Murphy sent me here to be his representative to ask some questions. So I don't deny that there is a sense, and I don't know, I didn't speak with Liam about this, but that there is a sense in which there is a moral sense in which people ought to behave to kind of, yeah, take care at some level towards others. But I can even concede that, you know, when you start thinking about tort law, it's useful to think in those terms. And, you know, I can tell when I teach my very first class in tort law, students don't know anything. And I just give them scenarios. And I say, what do you think? And at least on the basic cases, they get it right. But the reality of even negligence, once you go into the details, is more complex, which is exactly why we don't finish the first class and say, oh, now you know tort law. We teach them a whole semester of mostly negligence with lots of doctrines that don't actually always quite match. So for example, there's no liability for negligence for relational pure economic laws and even for other kinds. And this is, I can tell you, because I give in the first class some examples with pure economic laws, and students don't find this intuitive. They find it strange. Why should it matter? Also, so that's one sense that once you start going into the details, tort law does not match. Now you say, well, yeah, that's true. Negligence, there's a conventional parts of it, but then it strikes me that what you kind of move aside everything that doesn't fit. Well, that's a conventional part, but there is a core and that's what I'm talking about. But tort law is not the core. Tort law or negligence law is the whole doctrine. And once you kind of think about the whole doctrine, then the departures from sort of everyday morality are significant, I think. And so, and also, I mean, and here's one specific example that I think might be troubling for you, for your version, as opposed to the outcome inclusive view. So there is a sense in which the content of the duty, the standard of care depends on the potential, on the size of risk that you create. So therefore it actually does not, it's not that everyone owes the same duty. And then if you breach your duty, you pay as much harm as you caused. It's that the content of the duty to some extent depends on the potential harm. So you don't need to buy the full law and economic story, but something like the Hand formula is reflected in the doctrine. And the Hand formula does take into account the potential harm that you cause in determining the scope of the duty. And so this, so I have several issues. So I may have made 2 points here. So one is about, you know, parts of the doctrine that don't fit, like relational pure economic laws. The second one is the question about scope of duty that doesn't fit. And I'll finish with another issue, which is insurance. If you abolished insurance, tort law would collapse tomorrow. You cannot maintain tort law without insurance, which in many ways suggests that maybe we'll already everywhere live in something much closer to New Zealand than New Zealand. Yes, they have social insurance. That's privatized insurance, just like Obamacare is private health insurance as opposed to social insurance. But other than that, for the most part, we all have a mechanism of social insurance with respect to negligence, which is why the vast majority of cases are also not litigated. I think insurance is so you will say, okay, that's okay. I gave you the explanation. It's not a problem for me. But I want to talk about cases of insurance that's non-compulsory. So suppose someone burns your home, and I suppose you have loss insurance, home insurance. I imagine that you would be delighted about the fact that you have loss insurance, and you would not feel alienated by the fact. And the fact that you have home insurance that will give you compensation is not something that will trouble you, or is not something that when you decided to purchase it, you thought, well, but that maybe alienates me against the potential arsonist or the potential burglar. And so why is it that sort of people actually choose to not bother with this relational system when and therefore are self-alienating? So why is it that they actually go and purchase insurance if there is this problem that you identified? Thank you.
Sure. Thanks, Dan. So a number of really good comments. I'll go in reverse order. In a section of the paper that I wasn't able to get to, I explain why I don't think that liability insurance is a problem. And that's because it doesn't actually displace tort law in the way that workers' compensation schemes or New Zealand-style social insurance does. It rather complements it. So think about it in the way that, say, a Kantian thinks about duty. They say you should always act from duty, but they can live with you doing the right thing just because you want to, if it's the case that duty plays a regulative role. That is, it would step in to take over where you didn't want to, right? That's going to be acting from duty enough. So on my view, insurance can play that same role, right? You assigning your rights to someone else is not actually the alienating problem that you'll find in like a workers' compensation scheme. I think liability insurance is quite different in that way. Compulsory liability, but that's still you now just being forced to assign your right, but it's still the case that it's your right, right? I mean, even put it this way, compulsory liability insurance does not mean you have to use liability insurance when something bad happens. So I have to, as a matter of law, buy automobile insurance. It does not follow from that if I'm in an accident, I can't sue somebody. I can sue somebody if I don't think that the insurer will actually compensate me well enough, or for whatever reason, I'm still permitted. This is the way in which it complements but does not displace tort law, right? So even though I'm required to buy insurance, I don't have to use it when I'm in an accident. Of course, it's simpler to, right? So that's one piece. So another claim that you make is, you know, when having to do with, of course, the hand formula makes reference to and the content of our duties is sensitive to the harm that would befall anybody. Of course, risk is by definition risk of harm. So you're still taking into account what could happen were you to proceed with some risky conduct. So the fact that you take into account the fact that bad things would happen if you were to do this does not sort of dissolve my position into saying, but risk imposition alone can't be wrongful. That's all I'm saying. Risk imposition alone can be harmful, can be wrongful, even if it doesn't cause harm. When it's going to be wrongful is in part going to be explained by considerations that hand identifies, right? If you do something super risky that has a massive prospect of causing a massive harm, a high probability of a huge harm, that's going to, of course, determine when a risk that you've proceeded with is wrongful or not, right? It makes reference to the harm because by definition, risk is just probability of harm. Okay. Remind me, Dan, your first I had a great response to it. But I can't think off the top of my head. I didn't write it down. Okay. Oh, sure.
Yes.
Doctrinal stuff.
Doctrine is not, you know, the basic tort.
Yeah, so I actually, and I might be, you know, I might be more of a true believer than you are. I think a great deal of even the details of tort law have moral justifications, right? So I don't think it's true that things like rules against duties for pure economic loss, or oftentimes for pure emotional distress, right? Those I think are probably actually mistaken rules that tort law has. So I'm not here to sort of try to vindicate all of the particulars of the black letter law, right? I'm happy to say they could be unjustified, or if they are, they will be justified on pragmatic grounds. I mean, I think probably the justification for having limited duty rules for emotional distress, psychiatric injury, is historically because they had epistemic problems. It was harder to prove them. And so we introduced various reasons not to make them compensable. Likewise, with pure economic loss, you have a different sort of problem, which is just the pragmatic reason of not knowing when to sort of cut off claims, right? Otherwise, the ripple goes out forever down supply chains and everything, right? But that's just to say, sure, you can introduce instrumental considerations at the limit to sort of head off sort of just complicated problems. But I don't think that redounds to the detriment of the moral principle that all of it is based upon, right? That's just my point about not wanting to overstate sort of the scope and role of instrumental considerations, right? Of course they play a role, but the moral principles are sound. Murphy doesn't think there's anything there, right? It's instrumental all the way down. That's what I reject.
So I'm sure that there will be other questions, but in the interest of time, I have to draw this lecture to a close. So if you have any questions, I'm sure that Professor Oberdiek will be happy to answer by email. So thank you very much for joining us tonight, and I hope to see you again.
Thank you, everybody.